This is a Momentum Media production.
The SMSF Advisor Show. Your expert insights into the biggest themes shaping the SMSF advice industry.
Hi everyone, and welcome to the SMSF Advisor Show. I'm Miranda Brownlee, and I'm joined by Aaron Dunn, my co-host. Hi Aaron.
Hi Miranda, how are you?
I'm good. It's been a big news week finally this week.
Yes, and even in Melbourne, it's not about the tennis this time. So we're talking about SMSF. So Miranda, as is always the case, as we start off our SMSF Advisor Show, looking at what's making news, as you said, it's been a busy one. Let's get stuck into it.
Yeah, so we've had a couple of big announcements this week, starting with the government finally starting its consultation on fixing up the issues with NALI and general expenses. So we've had them release two potential proposals, which are not a settled position that the government's reached, but more something to kick off the consultation, I suppose. So one of those is that for SMSFs and small APRA funds, there's going to be a 5 times multiple tax rate applied where there's a general expense breach. And they've also proposed simply making APRA funds exempt from this general expenses issue.
Yeah, so I think the first thing is we should be hugely pleased as an industry that we've got something out, because I know there's been a lot of frustration for a long period of time trying to get some resolution to this. And in essence, now with Treasury releasing this consultation paper, and I believe it's open until about the 21st of February, that we've got at least a framework of which the government is looking to make amendments. Now, I know there'll be different views in the industry about whether that multiple is too high, whether the multiple is the right way, whether there should be some sort of ability to make an adjustment, but we've got something, and Treasury is now prepared through that consultation process and the questions that they've asked for feedback in respect to that. And then from that, we'll then see a decision made, bill introduced, and then potential changes to the law. So I think the positive is that we've got something now. There's a bit of debate about fairness and equity. So why is APRA carved out and self-managed super funds not? But let's just start the journey. And as I said, there's a month or so of consultation, and then we'll see what transpires thereafter.
Yes. And the other big thing that happened this week was obviously we had the CPI figure released, which dictates what the transfer balance cap will index to. So as the inflation figure was quite high, we did get the double indexation, which means it will go up to 1.9 from July onwards.
Yeah, so this, I guess, wasn't ultimately coming as a surprise, given the run rate, as you said, Miranda, of how CPI had been tracking. So our transfer balance cap is, of course, linked to CPI. Our concessional contribution caps, and those limits are linked to a WATI. So we don't know that figure yet, whether there's any change there. But this is kind of a double skip, isn't it? Because we're going from 1.7, not to 1.8, but to 1.9. So this will be quite opportunistic when we think about the ability to make contributions and the utilisation of the bring forward and so on and so forth. So a lot of those strategies that we spoke about from that 1.6 to 1.7 will then become relevant in the context of 1.7 to 1.9. And then we have our transfer balance cap considerations with the commencement of income streams and potentially the impact around reversionary pensions and the like as well. So the big caveat, of course, is between now and when indexation happens, we have that thing called the May budget. And we do know that Minister Stephen Jones has been quite active in saying that they will look at superannuation, not only the objective, but things around adequacy and so forth. So, yeah, this indexation, I say it will increase, but I also probably put an asterisk next to it, because whether the government will commit to allowing that to occur, we'll just need to wait and see.
Yes, and perhaps now that it has been the double amount, the whole 200,000, it might be more of a target than it would have been if it had only just gone up to 1.8 as well.
Yeah, correct. Absolutely.
So some of the other things that have been happening, there's obviously been a bit of lobbying in terms of these ABN reforms. So these, I think the draft legislation for this got introduced last year, and the SMSF Association has sort of highlighted that SMSFs aren't really the target for why these reforms are being introduced. and that's going to create, I guess, extra admin work and that kind of thing. So they've called for SMSFs to be made exempt from those changes.
Yeah, so this draft legislation, of course, was saying, well, where you potentially have more than 2 years of returns outstanding, they would look to cancel the ABN. And naturally, that ABN is a pretty important identifier in the context of self-managed super funds. If we think about compliance with SuperStream, we think about GST registrations and so forth. So naturally, as part of this consultation process, we've seen the SMSF Association highlight some of these challenges and parts to the SMSF sector that would be impacted by such a decision. And therefore, as a result of that, their preference would naturally be that we'd see some sort of carve out for self-managed super funds. As you mentioned, the fact that they're probably not the targeted area of what these measures are intended, but now self-managed super funds are naturally caught in it because of the requirement that they have that ABN in place.
We've also seen the ATO sort of continue that focused on illegal early release issues. So we saw them sort of speak about that becoming more of an issue last year, and they've just released a fact sheet sort of warning members not to pull out their super illegally and just be, I guess, wary of some of the promoters that are pushing these schemes onto people.
Yeah, and we spoke about, I think, Miranda, in our what's ahead for 2023, that I said, compliance, the ATO's compliance and focus on these types of areas will only grow. And I think this certainly forms part of that, where we're seeing a range of determinations being reviewed and practice statements around illegal early access and potentially the Commissioner's discretion. The ATO is spending a lot of time through their fund establishment process to ensure that funds are being set up for the right reasons. So, this kind of just fits into what you call their trustee education suite, the just making trustees aware that are becoming self-managed super funds, that you are a trustee, you do have responsibilities. It is not just simply a bucket that you can stick your hand in and take money out. And yes, there may be people that have been incorrectly or ill-advised around that, but equally you have responsibilities to it. So the more communication that can be provided to the marketplace at large, hopefully the more robust the system is, and the awareness that people have around the preservation requirements and the ability and the legal ability, obviously, for people to be able to access their superannuation.
So we're now going to be chatting with Matthew Burgess from View Legal, who's going to be talking to us about incapacity and how to deal with that with SMSF clients. So we're now joined by Matthew Burgess, founder and director of View Legal, who's going to be taking us through some of the issues and planning considerations for advisors or accountants in dealing with the issue of incapacity, particularly for SMSF clients. Welcome, Matthew.
Thank you, Miranda. Good to be part of the show.
So we discussed in an earlier podcast just before the end of the year some of the sort of demographic changes with SMSFs. There obviously is a much older sort of demographic emerging, which means issues like incapacity are becoming more important. So just to start off, Matthew, what are some of the steps that advisors and their clients should take to prepare for the possibility of a member in the fund losing incapacity?
Yeah, great question, Miranda, and I strongly endorse. We've all seen the numbers about the intergenerational wealth transfer, and obviously a material amount of the wealth being transferred is now tied up inside an SMSF. So that double whammy, if you like, of the wealth inside that environment, but then also people living longer and therefore at materially bigger risk of, being subject to some sort of incapacity event, means that in a practical sense, our sort of heuristic is you can never start too early as an advisor thinking about this stuff. And, obviously as people get older, there's that risk, but we all face that risk in everyday life. And the reality in many respects is that incapacity events are statistically far more likely to happen in the short term than a death event. But on top of that, when they do happen, they normally happen in a way where there's very little ability to find another pathway unless you've actually got the proper legal documentation in place. So to actually answer your direct question, I think the main rule of thumb that we have is be proactive in your scenario or your contingency planning around what might happen if a member does lose capacity. And that can be as simple as asking, multiple what if questions. So you hear in other environments people asking 5 whys, asking the why question 5 times. We sort of replace that in the debate in relation to incapacity and say, well, keep asking what if. So you ask, what if one member loses capacity? What if another member loses capacity? What if the people that they nominate to replace them don't have capacity? Now, at one point in that process, you're going to say, look, we've developed a completely wacky scenario. We don't care anymore. But there'll be at least, I suspect, 2, if not 3, what if questions that should be asked in order to answer your question.
So, Matthew, on that point, I guess what you're really reiterating here is that decision to put in place that enduring power of attorney is just as important in essence to the whole concepts of death benefit nomination. So we kind of go into that process of saying you get your fund set up, make sure you got your DBN in place. I mean, this document becomes as equally as important as the instructions you want with your will as to the decisions that you want to assist you when you can't actually make those decisions yourself.
Well, great insight, Darren. I don't think I could summarise it better than what you just said. It is almost a non-negotiable these days, and maybe that's the qualification, unless you're interested in making lawyers rich, unless you're a signed up member of the Benevolent Society for Poor Lawyers, you want to do it. Because otherwise...
Are there many members in that group, just out of interest?
I don't think in the SMSF space. Good answer. But yeah, no, you're right. You're 100% right. And in some respects, and we joke, I think the flip side to your point, and maybe this is where you're about to take us, is that there may well be a risk issue here for advisors that don't adopt the mantra that you just spoke to. And I don't want to be too doom and gloom about it, but the reality is that in this space, the litigious lawyers are ponying up, as it were. They're really getting active. And I think you're right. I think if you're going to be advising in the SMSF space and you choose to not deal with EDBNs and choose not to deal with incapacity, you're going to be at risk.
Mm. So I guess as we sort of have this discussion on incapacity, get you to somewhat explain the implications here of where a member loses capacity without an enduring power of attorney and the steps that could be taken. And the other thing, I guess, to make people aware of what that might look like when we have a single member fund too.
Yeah, awesome question. And it's not pretty. Is the simple answer. And the reality, well, again, it goes to the point we were making before in terms of lawyers making a whole lot of unnecessary money. There's no simple solution. The basic fallback position in each state is that there's a tribunal that has been set up to provide a pathway to effectively reconstruct an enduring power of attorney after the event. But that involves applications to the tribunal. There's no certainty as to what will be the outcome in relation to that application. And in the meantime, there's delays, and particularly in the SMSF space, particularly your example of a self-managed fund with only a sole member, that can be a huge problem. It can be a huge problem. And frustratingly, all of those problems would be resolved if you actually had a proper enduring power of attorney in place before the triggering event.
Yep.
The only other thing I'd probably add to go to your question a little bit there as well is to say that, it's one thing to have an enduring power of attorney. It's another thing to make sure that it's actually compliant from an SMSF perspective. And I would say they're 2 radically different points.
Yep.
Advisors and accountants obviously have quite a close relationship with their SMSF clients. Is there any kind of role they can play, or what kind of role can they play in helping the clients sort of prepare for incapacity and putting things in place to deal with that?
Having a few disclaimers today, aren't we, Miranda? With the disclaimer that obviously we're advisors in this space, and so we would always say it's sort of, turkeys don't vote for Christmas. Advisors in the SMSF space don't vote to avoid getting advice. I think the answer is an unequivocal yes. Yes, absolutely, advisors can take a leading role. But there's the point that we were touching on with Aaron a moment ago. From a risk perspective, maybe we either need to in order to be providing competent advice, or if we're choosing not to, we need to be getting off risk. And so we're excluding advice in this area. We're telling you to go and get it elsewhere. Speaking more positively, I would have thought, again, it's about being proactive in asking calibrated questions. So being on the front foot, having as part of your annual checklist, basically, as talking about BDBNs, most advisors that specialise in the space will be asking questions around BDBNs on an annual basis. So too, they should be asking what happens in the event of an incapacity, what exactly will occur under the enduring power of attorney. And for those customers that don't want to engage in that process, I think the other thing we'd mention, and we're getting so much content on this, I suspect the year ahead will be exactly the same, is that there's just so many war stories that you can share to hopefully help be a catalyst in people actually making movement in this space. Because like the wider estate planning piece, probably the biggest challenge we're all going to have as an advisory industry is inertia. The customers just forever putting the issue off and then, Murphy's Law taking over.
Yeah, and I was about to kind of expand on what you're saying there because, we have seen the ATO some time ago give us some guidance around, appointing EPAs to the role of trustee and the fact that if you've got multiple attorneys, those multiple attorneys could step in or an individual there might. And these then all become really critical questions that you actually have to have those discussions with. So if, as you said, a specialist advisor isn't kind of going in discussing this at day one and expecting it to kind of just lie low for the next 15 or 20 years or whatever the cycle of that fund is. These are all conversations that we're seeing. And from your point of view, do you see scenarios where there will be a one party maybe stepping in for specific reasons, or is there parts of the EPA that are being drafted in a particular way, or what are some of the things that you're kind of seeing at the coalface?
Yeah, I mean, you've touched on a number of great examples there, Aaron. And to me, that question's almost an entire episode in itself because you can just unbundle that on a continual basis. But let me share one just recently that we had where the member had appointed 4 attorneys.
Yep.
Now, you say, okay, well, that probably makes sense, except that they required all 4 attorneys to sign jointly under the document. And when the incident happened, there was an accident that the member was involved in. There were some urgent decisions that needed to be made. That they could only allocate one of the 4 attorneys. So it then spiraled into, classic legal debate about whether the fact that 3 of the attorneys were missing in action, whether that prohibited the final attorney for acting. And then to go to your SMSF point, it then raised an even bigger question, and that is, well, when the other 3 did turn up, was it a matter of all 4 of them being appointed to the board of the corporate trustee, or could one of them, effectively act as a nominee for the others? Now, all of those questions should have been answered well before the car crash took place.
Yeah. So I guess any other tips that you have for SMSF clients, obviously looking to this process or they've gone through this process and other traps that naturally come into this space as well that professionals should be looking out for?
I think it goes to a little bit of the thing that we just spoke about there, but indeed each of the points we've been making, that 90% of the game here is in the preparation, and none of this stuff is actually that hard with hindsight. None of these issues are particularly traumatic, and as you touched on, the tax office has been in writing for years about what they expect from an SMSF perspective. So the ability to overlay that with a holistic estate plan in theory should be pretty simple. From our perspective, probably the biggest one, and it's easy for us to say in isolation, is that to actually be proactive as the advisor in asking these questions early. So don't leave yourself in a position where it's come up, the issue becomes a live issue when it's too late to actually do anything about it. And that can be, you use examples that you've seen with other customers in your client base as almost as a checklist to then go into the next situation and keep that. We hear about chatbots and whatever else giving the answer off the shelf. Well, build your own. Have an internal system whereby you're actually collating examples of where things have been done well and, frankly, where things have not gone as well, and use that to build your checklist as to how you're going to roll out the strategy to your customers or get off risk. And so I don't want people to walk out of today's program to think, suddenly we've got another thing that we've got to go and deal with each year. But if you're choosing not to advise in this space, which, it's your personal decision as an advisor, I would at least say you need to make sure that you're getting off risk and making sure that someone's accountable and responsible for getting this stuff in place.
Yeah, I would say if you're involved in Section 17A, you're involved in the whole of Section 17A, including subsection 3.
This is why you and Miranda are the hosts of the program. Great response.
Yeah.
Well, thank you so much for joining us today. You've given us a lot of useful insights there and some practical tips as well. So thank you.
Thanks so much, Miranda.
Excellent. And we'll see you at the National Conference in February.
Looking, counting down the sleeps. Great to see you.
Very, very much. All right. Thank you, Matthew. Yeah. Much appreciated. I'm sure our audience has got some great insights into enduring powers of attorney today. Take care.
Stay well.
So, Miranda, that was, as was always expected from Matthew Burgess, hugely insightful and practical insight into the issues around enduring powers of attorney. For you, what was the key takeaway?
I thought it was very interesting how he talked about the risk aspect of not sort of addressing these things. I mean, we often hear about risks of, I guess, advisors helping clients with things like binding death nominations or these kind of documents, but there's also a risk in not addressing it at all as well, which I thought he explained really well.
Yeah, and I agree entirely. I think that risk management in your practice is critical, and that's why I kind of jokingly made that comment around that. Well, if you're involved in Section 17A, you kind of got to be involved in the whole thing, and we know that death is an issue. We know that incapacity is an issue. So highlighting these things is of utmost importance. I think it was great that he was able to kind of give a insight into a real practical example at this point in time. And yeah, one of the challenges, I guess, when we look at the fact that advisors are so wedded into the whole BDBN process now is because we've got that clear guidance within the SIS laws. And then, of course, our High Court decision of Hill and Zuda talking about the way in which the BDBN needs to be constructed. In an EPA sense, we've got different states that we need to deal with around the appointment of it. So it's not as straightforward a process as what we do have when it comes to binding death benefit nominations. Maybe that throws some people off, but it is as equally important to get this part of the succession right inside the self-managed super fund. And as I said before, I think Matthew explained that extremely well.
Yes, I think he highlighted sort of the importance of not overcomplicating these things as well, and just, making sure it's all going to work. I like the what if, the what if type of thing. So it's kind of, peeling layers off the onion to make sure you're getting to the crux of the issue rather than just kind of saying, well, actually, is that really the answer that we want? Is that enough? Let's kind of just peel another layer off to make sure we've got the outcome. And to use that in that example about the 4 enduring powers of attorney and then the issues that were a part of that to try and get that particular matter resolved and the assets and stuff that were in the self-managed super fund. So, Miranda, to you, if people do have any other questions, ideas for topics, suggestions, how can they get in contact with us? So they can get in touch at editor@smsfadvisoronline.com.au.
Excellent. Well, thank you once again for joining us for our SMSF Advisor Show. Take care, and we look forward to you joining us for our next episode. Bye for now.
Imagine being rushed to hospital.
Yep.
And your life changing in an instant. Imagine going through hundreds of tests and 46 weeks of chemo. Now imagine you're a child. That's why Starlight exists, to bring happiness to seriously ill children. Please donate at starlight.org.au.